We are going to cut out of that case in Las Vegas, Nevada, because we have some breaking news in the Idaho student murders case. Bryan Kohberger, he was in court today for a status conference where he waived his right to a speedy trial. That hearing just wrapped up, and now we can bring it to you. So let's listen.
Yeah, go ahead. So, Mr. Kohberger, did you read this over?
Yes.
Okay. What I'm talking about is the written waiver of speedy trial.
Yes.
Did you understand the terms here?
Yes.
Which we've already talked about.
Yes.
And you agree with the signing of the form waiver of speedy trial, Ms. Taylor?
I do not.
Okay, so Mr. Kohberger, do you want me to accept your waiver?
Yes, I do.
Okay, and you understand that if I accept your waiver, you're giving up your constitutional right under the United States Constitution and the Idaho Constitution on a constitutional right of speedy trial?
I understand.
Do you understand that if I accept your waiver, you're also giving up your Idaho statutory right to a speedy trial?
Yes.
And that is within 6 months of your arraignment?
Yes.
And you agree with the vendor of the waiver, Ms. Taylor?
I do not.
Kohberger, do you want me to accept the waiver?
I do.
Based on our discussion, your waiver of these rights expressly in court and also in signing this waiver of speedy trial. Also, you are tendering these waivers on advice of counsel. I will accept your waiver of speedy trial. I find that your waivers are knowing, intelligent, and voluntary, and there's actually good cause to recognize that. Actually, what I heard from your counsel, Mr. Thompson, and my mind. So, with that, we can talk about resetting this trial. Prepared to do that today. Sarah?
Your Honor, I would say that we are not prepared to choose the trial date today. That brings me to the second part of what I wanted to talk to the court and counsel about today. We currently have September 1st as the date for the motion to dismiss the grand jury indictment. Our deadline to file our challenges will be today, and we're prepared to file those today. Our hope is that that particular hearing date, we like to keep it, both challenge the grand jury indictment, and also there are 2 additional motions that we're going to be filing, and we're hoping that we can have those heard. After that time, after we've heard the motions, we'd be in a position to meet with the state if they desire and talk about a reasonable trial setting. My preference would be to have us discuss that and reset the trial one time and not do this a number of times and worry about getting subpoenas out and worry about the That would be my request. The other deadlines that are in place right now on the court's scheduling order, I think those would be appropriate for us to talk about and state and defense and perhaps suggest for the court to order a different scheduling order than one that exists. We just simply want to keep the grand jury indictment challenge date because that's soon, and having the court's decision on that will largely impact what happens next. If the court will allow I'd like to briefly address the other two motions that are pending in the content file today. Your Honor, we will be filing a motion that has to do with media in a courtroom, particularly for cameras in a courtroom. And that motion should be filed by the end of the day or first thing tomorrow. That comes from the things that happened last week. The other motion, Your Honor, has to do with what happens to witnesses that the defense might protect. The court will recall we had Gabriela testify last Friday. In our hearing last night, she was visited by 2 FBI agents and interrogated about her testimony, the timing of the declaration. That, in our view, impacts Mr. Kohberger's due process rights and his rights to effective assistance of counsel, and that motion will also be filed later today at first thing tomorrow.
Okay, so that was some breaking news that did happen earlier today. We were finally able to play that for you. Bryan Kohberger, we heard him speaking there, waiving his right to a speedy trial. We do need to take a break here, but we do have much more from the Bryan Kohberger hearing. You won't miss a minute, so keep it right here. You are watching Court TV, your front row seat to justice.
Tonight on Closing Arguments, 2 previously dismissed sexual abuse lawsuits against Michael Jackson have been reinstated by an appeals court. So what does all of this mean for the estate of the late singer? And what we learned from today's status hearing in the Idaho college student murders. Did the defendant waive his right to a speedy trial? And what might that mean for this case moving forward?
Closing Arguments with Vinnie Politan, tonight at 8, 7 Central, only on Court TV.
And welcome back to Court TV Live. We are continuing to follow the Idaho student murders case. Defendant Bryan Kohberger was in court today for a status conference where he waived his right to a speedy trial. We turned this tape around immediately, so we apologize for any technical glitches that you might see. And you also may notice a static noise. That's in the court feed. That's from a fan that was in the courtroom. So if you hear it, that's what it is. We have more now from that hearing, which just wrapped up.
Genetic genealogy field. Those indicated as it was reported to the investigators, to our investigators, that she was related on some of the things that she testified to in court. When we heard of that, I reached out to the investigators and said, can you find out what's going on? And the FBI indeed undertook an investigation. And preliminary reports are that as far as claims that some of what was in her declaration, she inadvertently agreed or signed without fully reading it. We're documenting that so we can expose it to Ms. Taylor and to the court, because I think it goes directly to what happened last week. That's the only reason that she was found out, because it reported to us that she was retracting some of what she had testified to and what was in the declaration. And we felt imperative we need to uncover that system. There was no other motive, no other motivation to it. I just wanted to change the court.
Your Honor, that's certainly different than the information that I received. I would have been happy to be advised about that, but I'm not sure that's...
That's how we sort these things out.
Correct.
So,
Your Honor, that's certainly different than the information that I received. I would have been happy to be advised about that, but I'm not sure that's accurate. I mean, I'm sure that's what Mr. Thompson heard. I'm not saying that I'll be a letter, but the quality of the information he's received, I'm not sure that's entirely accurate. My hope is that these two FBI agents that were at Gonzalez's home last night, hopefully they reported everything that they talked to her about, and that should resolve the issue.
good case.
You're about it at the hearing.
That's how we sort these things out. So back to a change of the scheduling order. I think it does make some sense to review that. You want to just talk about that before we start taking that apart? We don't have to do it right now.
Judge, the state's position to be is that the court vacate the October trial date, vacate the scheduling order, let us get through what we're going to do on the 1st, and then let's talk and see if we can come to an agreement. If not, allow the court to set a date for trial that's realistic, and then have a scheduling order generated that reflects the time of preparing for trial and is useful for both parties to do what they need to do.
Acceptable, Ms. Taylor?
Yes, Your Honor, I agree. We should get through the hearing on the 1st, and then we're happy to meet with Mr. Thompson in his office and discuss the appropriate trial date.
That counsel can talk about some of those things before they're taking it back to the court.
Yes.
I am fully supportive of that. So I'm vacating the trial October 2nd. I'm vacating the scheduling order except for September 1st. Okay? Accepted Mr. Kohberger's waivers, speedy trial. I have maybe a personal issue to discuss with you. First of all, I wanted to tell you I'm getting requests for excuses already from potential jurors, and what I'm doing is not excusing anybody at this point. The commissioner, jury commissioner, is just collecting those, and then we're going to do those excuses on the record with you. Okay, I think that's appropriate in a case like this. Does that make sense, Ms. Taylor?
The excuses are from potential jurors.
They may be needed. I mean, these are expanding the panel. Okay, because I was thinking that I need a lot more potential jurors to show up.
And we're going to pause things right here for a really short break. So don't go anywhere, because when we return, we'll get you more back into that courtroom for the hearing in the Idaho student murders case. So keep it right here. You're watching Court TV, your front row seat to justice.
Tonight on Closing Arguments, 2 previously dismissed sexual abuse lawsuits against Michael Jackson have been reinstated by an appeals court. So what does all of this mean for the estate of the late singer? And what we learned from today's status hearing in the Idaho college student murders. Did the defendant waive his right to a speedy trial? And what might that mean for this case moving forward?
Closing Arguments with Vinnie Politan tonight at 8/7 Central, only on Court TV.
And welcome back to Court TV Live. We do have some breaking news in the Idaho student murders case. Defendant Bryan Kohberger, he was in court today for a status conference where he waived his right to a speedy trial. We turned this tape around immediately, so we do apologize for any technical glitches that you noticed. I noted earlier when we were watching it, there were some pauses there. You may also notice a static noise, so that's kind of in the feed too. That's from a fan in the courtroom. So just try to listen closely and you can get more of what's happening in court. So let's get you some more from that hearing.
So, Mr. Kohberger, did you read this over?
Yes.
Okay, what I'm talking about is the written waiver of speedy trial.
Yes.
Did you understand the terms here?
Yes.
Which we've already talked about.
Yes.
And you agree with the signing of the form waiver of speedy trial, Ms. Taylor?
I do not.
Okay, so Mr. Kohberger, do you want me to accept your waiver?
Yes, I do.
Okay, and you understand that if I accept your waiver, you're giving up your constitutional right under the United States Constitution and the Idaho Constitution on a constitutional right of speedy trial?
I understand.
Do you understand that if I accept your waiver, you're also giving up your Idaho statutory right to a speedy trial?
Yes.
That is within 6 months of your arraignment.
Yes.
And you agree with the vendor of the waiver, Ms. Taylor?
I do not.
Kohberger, do you want me to accept your waiver?
I do.
Based on our discussion, your waiver of these rights expressly in court and also in signing this waiver of speedy trial. Also, you are tendering these waivers on advice of counsel. I will accept your waiver of speedy trial. I find that your waivers are knowing, intelligent, voluntary, and there's actually good cause to recognize that. What I heard from your counsel, Thompson, and my mind. So, with that, we can talk about resetting this trial. I'm prepared to do that today. Sarah?
Your Honor, I would say that we are not prepared to choose the trial date today. That brings me to kind of the second part of what I wanted to talk to the court and counsel about today. We currently have September 1st as the date for the motion to dismiss the grand jury indictment. Our deadline to file our challenges will be today, and we're prepared to file those today. Our hope is that that particular hearing date, we'd like to keep it, both to challenge the grand jury indictment, and also there are 2 additional motions that we're going to be filing, and we're hoping that we can have those heard. After that time, after we've heard the motions, we'd be in a position to meet with the state if we desire and talk about a reasonable trial setting. My preference would be to have us discuss that and reset the trial one time and not do this a number of times and worry about getting subpoenas out and that would be my request. The other deadlines that are in place right now on the court's scheduling order, I think those would be appropriate for us to talk about the state and events and perhaps suggest for the court to order a different scheduling order than one that exists. We just simply want to keep the grand jury indictment challenge date because that's soon, and having the court's decision on that will largely impact what comes next. If court will allow, I'd like to briefly address the other 2 motions that are coming and have not been filed today. Sure. Your Honor, we will be filing a motion that has to do with media in a courtroom, particularly cameras in a courtroom. And that motion should be filed by the end of the day or first thing tomorrow. That comes from some things that happened last week. The other motion, Your Honor, has to do with what happens to witnesses that the defense might have. The court will recall we had Gabriella Vargas testify last Friday. In our hearing last night, she was visited by 2 FBI agents and interrogated about her testimony, timing of the declaration. That, in our view, impacts Mr. Kohberger's due process rights and his rights to effective assistance of counsel, and that motion will also be filed later today or Thursday.
Any objection to hearing this here, the motion along with these 2 more motions to be heard on September 1, Mr. Johnson?
I don't believe so, Your Honor, having not seen exactly what the motions are, but understanding they're fairly straightforward. I would think that we considered. As we look at motions, we have an issue with raising Ms. Taylor. I will, for the record, since Ms. Taylor has brought up the situation as far as getting a court and counsel background. Over the weekend, Ms. Vargas, after she testified, engaged in some electronic communications with others.
All right, we are continuing to watch that breaking news out of Idaho, where Bryan Kohberger waived his right to a speedy trial. We do also have some new developments in the widower murder retrial in Nevada. We are now in verdict watch. You can see the clock that's on the screen right now. They have been deliberating for about 15 minutes, so we are keeping a close eye on what's happening out there in Las Vegas, Nevada. We're going to pause things right here for a short break. When we return, more from today's hearing in the Idaho student murders case. Keep it here for your front row seat to justice.
Tonight on Closing Arguments, 2 previously dismissed sexual abuse lawsuits against Michael Jackson have been reinstated. Our experts break down these fascinating developments.
Closing Arguments, coming up next, only on Court TV.
These are the cases that captivated the world.
Couldn't keep my life straight.
They were killed by their own children.
Court TV, Legendary Trials. Go to courttv.com/legendary trials to find out how to watch.
And welcome back to Court TV Live. We do have some breaking news in the Idaho student murders case. Defendant Bryan Kohberger, he has waived his right to a speedy trial during a hearing that took place today. We did turn this tape around immediately, so again, if you do hear any technical issues, you may also hear this glitch, just we apologize in advance for this court feed that we got in. And remember, it's just a fan in the back, so try and listen closely if you can. Here's more from that hearing.
Genetic genealogy field. Those indicated as it was reported to the investigators, to our investigators, that she was redating on some of the things that she testified to in court. When we heard of that, I reached out to the investigators and said, can you find out what's going on? And the FBI indeed undertook an investigation. And preliminary reports are that Ms. Vargas claims that some of what was in her declaration, she inadvertently agreed or signed without fully reading it. We're documenting that so we can expose it to Ms. Taylor and to the court, because I think it goes directly to what happened last week. That's the only reason that she was contacted, because it was reported to us that she was retracting some of what she had testified to and what was in her declaration. And we felt it very easy to cover that too. There was no other motive, no other motivation to it. I just wanted to thank the court.
Your Honor, that's certainly different than the information that I received. I would have been happy to be advised about that, but I'm not sure that's.
The hearing. That's how we sort these things out.
Yeah.
So,
Your Honor, that's certainly different than the information that I received. I would have been happy to be advised about that, but I'm not sure that's accurate. I'm sure that's what Mr. Thompson heard. I'm not standing here calling him a liar, but the quality of the information please see, I'm not sure that's entirely accurate. My hope is that these 2 FBI agents that were at Ms. Vargas' home last night, hopefully they reported everything that they talked to her about, and that should resolve the issue.
great. The hearing. That's how we sort these things out.
Yeah.
So back to a change of the scheduling order. I think it does make some sense to review it. We want to just talk about that before we start taking that apart? We don't have to do it right now.
Judge, the state's position would be is that the court vacate the October trial date, vacate the scheduling order, let us get through what we're going to do on the 1st, and then let's talk and see if we can come to an agreement. If not, allow the court to set a date for trial that's realistic, and then have a scheduling order generated that reflects the time preparing for trial and is reasonable for both parties to do what they need to do.
Is that acceptable, Ms. Taylor?
Yes, Your Honor, I agree. We should get through the hearing on the 1st, and then we're happy to meet with Mr. Thompson in his office and discuss the appropriate trial date.
That counsel can talk about some of those things before we're taking that to the court.
Yes.
I fully support that. So I'm vacating the trial October 2nd. I'm vacating the scheduling order except for September 1st. Okay? So accepted Mr. Kohberger's waivers, speedy trial. I have maybe a personal issue to discuss with you. First of all, I wanted to tell you I'm getting requests for excuses already from potential jurors, and what I'm doing is not excusing anybody at this point. The commissioner, hearing commissioner, is just collecting those. And then we're going to do those excuses on the record with you. Okay, I think that's appropriate in a case like this. Does that make sense, Ms. Taylor?
The excuses are from potential jurors who are not needed.
They may be needed. I mean, these are expanding the panel. Okay, because I was thinking that I need a lot more potential jurors to show up.
All right, we do want to bring in one of our guests tonight, criminal defense attorney Elizabeth Baker. Hi there, Elizabeth. Okay, so we have been watching this hearing where Bryan Kohberger waived his right to a speedy trial. Now, it seems like we don't know when this trial could get underway. What are your thoughts?
Well, I'm shocked they didn't waive prior to this time. That would be the normal course in a case of this magnitude, especially a death penalty case. It is something that, I mean, what I believe is that the defense probably hadn't waived the speedy trial issue because they were hoping to have their client testify at the preliminary hearing and or at least test the state's evidence out at the preliminary hearing. It sounds like there may be some motions about the preliminary hearing or the indictment process that the defense is going to be filing. But this is completely within the norm for a case of this magnitude. There is what would be really out of the norm was to have a case like this go to trial within a year. I mean, these homicides were last November, and that would sort of be asking for this trial to be tried multiple times because of constitutional errors.
Yeah, his attorney even argued and said that this ensures that he will have effective representation, which of course is extremely important. Elizabeth, thank you. I also want to bring in Court TV legal correspondent Chanley Painter. She has been covering the Idaho student murders case from the very beginning. So Chanley, I want to bring you in to get your take. What do you make of Bryan Kohberger's decision to waive his right to a speedy trial?
Great to be with you again, Kelly. I think it was to be expected, given the hearing that we were present at last Friday and the really intricate scheduling conference and order that was issued saying that certain deadlines for certain dates to meet that October 2nd trial date that was still set, and it is a death penalty case. And at that point, the prosecution, raised the red flag, saying it seems pretty unrealistic. But at that time, the defense didn't waive the right. They instead asked for this status conference, possibly to sit down and discuss it further with their client. We know in the state of Idaho, Kelly, that a defendant has to be present in person at a hearing in order to waive a speedy trial, because there is that colloquy back and forth with the judge that happened today. So it was to be expected. I've been in communication with the victim, Kaylee Gonzalez's family, over the last several days, and today just now communicating with her father and how they were fearing this because they want this to happen as soon as possible, some sort of closure and justice, and they're afraid now that since he's waived the speedy trial right, that it may put this years from now before they actually receive full justice for Kaylee and her friends, the other victims in this case. So we do still know that as far as right now, there's still a hearing for next Friday to take up the defense motion to dismiss. They're trying to attack the very indictment against him. They actually asked for a stay several weeks ago so they could further investigate the grand jury process. That was granted and fulfilled, so we can expect them to still be challenging every step of the way what the prosecution does, Kelly.
Yeah, Chanley, and you did mention Casey Gonzalez's family, and I know they've been so active on Facebook. You've had encounters with them, too, and they really were saying that they really feared this because, as you mentioned, now this could go on for years. And when you talk about any kind of closure, not that there ever could be any closure for family in this case, but before it was supposed to be set for October. Now it could be years. Just heartbreaking news for the family. They said that this was something they feared, as you mentioned. Anything more from them?
Absolutely. Yeah, absolutely, Kelly. In communicating with them, and like you said, they do have a very active Facebook page, the Gonzalez family Facebook page, where they post people that send them encouraging messages and gifts from all over the world, and they post photos and updates about, Kaylee's new niece that's named after Maddie and Kaylee. Her name's Maddie Kay. They post photos of her, of the dog Murphy that was at the scene when the murders happened as well. There's updates on him, the dog, and they posted earlier today asking for prayers because this was such a fear. Especially Kaylee's mother, Christy, is very in distress at this decision. And so, what I know of them, and I've seen them in person, met them in person, obviously. They are each other's support system, and so they have each other through this time, and that seems to be where they're going. And there wasn't a trial date set yet, Kelly, so that's another sign that it may be a week or two or more before we learn an actual trial date for them. And we know with death penalty cases, it's a lot more complicated and a lot more filings to come that we'll be covering as this moves forward.
Sure. And Chanley, we did hear the judge talk about jurors and how he is already getting excuses from potential jurors in this case. I just think it's really going to be tough to find some jurors who don't know anything about this case. I would think the excuses are going to keep on coming.
Absolutely, Kelly. That's a great point that you bring up. I've been to Moscow, Idaho, many times. I've lost count of how many times I've been there in that community. It's a wonderful community. Latah County is a beautiful place to be. It's a rural, small part of North Idaho, and everywhere you go, people know about this case. Of course they know about it, and it's kind of like the elephant in the room. A lot of them don't even want to talk about it or mention it. They want to move on from it, and it's a university town, so the town of Moscow is maybe around 11,000 in population, but when students are there, it's like 20,000. It's like doubles in population when school's in session, so it's very much a college town, not far from Pullman, Washington, another college town as well. So I can see where the judge is concerned, and they're going to have to make sure that all the precautions are in place to impanel a fair and impartial jury. I know that he mentioned he was going to summon 1,000 jurors the week before, the October 2nd trial date to try to narrow it down to those prospective jurors, Kelly. So that will probably be heavily litigated. Will we have a change of venue motion, too, from the defense? Because, again, it's such a rural community there where so many people are familiar with this case.
And, Chanley, I'm glad you bring that up. So thank you for talking about that and your insight. I want to ask our criminal defense attorney, Elizabeth Baker, who's still with us. What do you think? Do you think we'll see a motion for change of venue in this case?
Sure, I do. It's a very small community. It's going to be difficult to get that many jurors. who are neutral and don't have a preformed opinion about the case. I don't necessarily expect that that motion would be positive for the defense. I don't necessarily think it would be granted, but I think it would be expected, absolutely.
Elizabeth, I just also want to ask you about this motion to dismiss hearing that his public defender has talked about. She's fighting this grand jury indictment that led to Kohberger's arraignment. They mentioned that briefly during the hearing today, talking about that as well as other motions that she's going to be bringing forth. She mentioned she's going to have at least 2 more additional motions in addition to that one. What are your thoughts on that and that motion to dismiss?
You know, there could be a number of reasons for the motion to dismiss. It could be that the defense believes that hearsay or inadmissible evidence was presented to the grand jury. I'm unclear about the specific basis. We're probably not going to know more until the motion and its detail is filed with the court and becomes public knowledge. I would say there are probably some technical issues. The problem with motions to dismiss grand jury indictments is that very frequently there's no remedy. And, you know, it's very difficult to the court to formulate a remedy. What is the remedy? Is it re-indictment? The case surely won't be dismissed on the basis of a motion like this. I mean, you know, who knows what the defense is saying? If they're saying there was misconduct, you know, if they're saying there was hearsay, they were saying there's other evidence which is clearly not constitutionally admissible. You know, we'll have to see what the details are about this.
All right, Elizabeth, thank you so much. We appreciate your insight tonight. It's been a pleasure being with you and hearing from Chanley in this case. And Chanley's just been all over the place. She's been in Las Vegas covering the Randolph case, which has been exciting to watch, and also bringing us some insight tonight about the case in Idaho where Bryan Kohberger waived his right to a speedy trial. Some breaking news for you there. Now, coming up next, it is closing arguments with Vili Politan. He's going to wrap up today's hearing that took place in the Idaho student murders case, and a California appeals court revived lawsuits from 2 men who allege Michael Jackson sexually abused them for years. One of Jackson's former attorneys, Mark Garagos, joins Vili Politan live to discuss. It's an interview you do not want to miss. That's right here on Court TV at 8 p.m.